Well, welcome to this last session of our seminar on judicial history and ecclesiastical justice in viceregal Spanish America. And today we have the great honor of having with us Professor Kenneth Pennington, whose books and articles have contributed to the education of several of us. Professor Pennington's work has been of great importance to Jorge Traslosheros, and I am particularly happy that Jorge's research stay at our institute and the organization of this seminar have also been the occasion for this meeting, albeit from a distance. It is not possible in a short presentation to summarize the wealth of Ken Pennington's scientific output, but I would like to give some insights of his educational backgrounds and his main lines of research. He received his PhD in medieval history from Cornell University in 1972. For 30 years, he taught medieval and Renaissance history at Syracuse University. Since 2001, he taught as Kelly Quinn Professor of Ecclesiastical and Legal History at the Columbus School of Law and the School of Religious Studies at the Catholic University of America. And then he retired in 2017 and became emeritus. According to his own words, in his research, he has been particularly concerned to illustrate how the norms created by medieval jus commune shaped medieval institutions, thought, and society. But it has ranged far beyond from this framework, including almost among its areas of interest, also ancient, medieval, and early modern history, legal history, history of constitutional thought, political theory, church history, university history, and paleography. It is not possible to recall all of his publications here, including 14 volumes and more than 100 essays. However, I would like to mention two initiatives that have certainly left their mark in our discipline and contributed to enriching the discipline. First, the publishing project started in the late 1980 together with Wilfred Hartmann, aimed at writing a new history of medieval canon law. In the context of the project, which involved more than 50 researchers from 13 different countries, important collective volumes have been published, including the history of course and procedure in medieval canon law that you can see here and that I will circulate gladly here in Frankfurt. And as far as I know, this became one of the favorite books of Jorge Traslosheros in this last month. Secondly, with Manlio Bellomo, Orazio Condorelli, and Wim de Kock, Professor Pennington directs the International School of Jus Commune in Erice, Sicily, which is part of the Centro di Cultura Scientifica Ettore Majorana. As many of you are aware, the school's annual courses have over time become an almost obligatory stop for many young researchers. Today, Professor Pennington will talk about the evolution of court procedures and the judicial use of torture, and probably also some other topics. And after the presentation, Jorge Traslosheros will give a brief commentary, and then we will move on to a question and comment session from the audience. So Professor Pennington, very welcome in this seminar. I leave you the floor, thanking you again for accepting our invitation.
Thank you very much, Benedetta. Thank you, Jorge, for the invitation to come to Frankfurt, even if it is only via Zoom. Unfortunately, you can't have a good Frankfurt beer via Zoom. So we'll have to forego that pleasure for the next time that I'm in Frankfurt. Today I'm going to give a survey of the development of legal procedure and also one of the great stains that is on medieval legal procedure, discuss the beginnings and the use of torture in medieval secular as well as ecclesiastical courts. And Benedetta, if my microphone starts failing me, will you give me a signal of some sort that we can deal with that? All right. Incominciamo. And I think you all know, in general outline, how medieval procedure developed. And I must say that after studying medieval procedure for almost 40 years, I've been impressed that it's probably the most significant, or at least one of the most significant contributions that medieval jurisprudence has made to the modern world, because particularly in the civil law tradition, and I think almost all of you sitting around the table are part of the civil law tradition, the procedural norms and the court procedure itself is primarily based on the procedure that the jurists developed from the 12th through the 17th centuries. And what I have up on the screen is, in a very rough fashion, how the procedure developed. As you probably all know, in the early Middle Ages, before the revival of jurisprudence and law schools in the 12th century, the ordeal seems to have been a very important part of how legal cases were settled. And from the beginning of the 12th century, we had a development, first a accusatorial procedure developed in the 12th century, and then in the second half of the 12th century, an inquisitorial procedure developed, and during the course of the 12th century, the jurists wrote many tracts on what they called the Ordo Judiciarius, or what they called a handbook on how a procedure ought to be developed in the courts. And finally, if I may say, the most important part of the jurist's contribution to modern procedural norms is the idea of what in English and French is called due process, and what the medieval jurists called secundum ordinem judiciario. Let's begin with the ordeal. And I'd like to begin with this magnificent painting, or drawing, I should say more accurately, from a Lambach manuscript that dates to the end of the 11th century, showing the ordeal. The ordeal was a simple, yet not entirely uncomplicated procedure. On the left-hand part of the screen, you see the priest is blessing the hot iron, which is going to be used to determine whether the defendant is on the right side of the screen. And what I find particularly interesting about this particular illumination is that the defendant is being embraced by one presumes an angelic figure. At least the way she is floating, she doesn't seem to be a figure that is connected with living human beings. And our defendant is ready to grasp a hot iron to walk around for a stipulated period of time. And depending on how the burns on his hands heal, the people will decide whether he is innocent and guilty. The main point I'd make about the beginning of procedure is that an ordeal could not have an appeal. There's no way that you can appeal from God's judgment. The other point that I would make, if you look at the footnote at the bottom of the page, is that some historians, like Robert Bartlett, have argued that the ordeal lasted and was used during the 12th century and only was discarded at the beginning of the 13th century when the Fourth Lateran Council outlawed the ordeal in ecclesiastical courts. And that, to put it bluntly, is just nonsense. There is no proof of the ordeal being used in ecclesiastical courts during the 12th century. There is some proof, very little proof, that it was used in secular courts. What is interesting about the way in which procedure developed in the 12th century is that if you were going to change procedure in the courtroom, you had to have a very good reason for changing it. If one can imagine what it would be like if a bunch of jurists in European law schools suddenly decided that the civil procedure was no longer a valid procedure and that they should be using another procedure completely different. You have to have a reason. And what the reason was for adopting the new procedure that was primarily based on Roman law norms during the 12th century was that they attributed the beginning of the Ordo Judiciarius, and I'll use that particular expression in talking about the medieval procedure that develops. They decided that a text in Genesis chapter 3, verse 12, established the Ordo Judiciaris. And Paucapalia, a commentator on Gratian's Decretum, was the first to make that connection. But the important thing is it gave Paucapalia's gloss. Paucapalia's gloss gave a significant rationale for the Ordo Judiciarius that then was accepted by everyone, by every proceduralist who wrote about procedure until the 17th century. At first, this new type of procedure was accusatorial. What that meant was that if you were bringing a court case against someone, you had to have an accusation. There had to be an accusation by a plaintiff, an auctor, to use the Latin word. You had to have an accusation in order to bring the case to court. And again, the older legal tradition believed that the accusatorial procedure was used throughout the 12th century and was only changed at the Fourth Lateran Council by a series of canons promulgated by Pope Innocent III. The work of Lautecari and others has shown that this is not true. That in the second half of the 12th century, judges within ecclesiastical courts, but also within secular courts, began to investigate, to make an inquisition into a particular legal problem, and that the canons that were promulgated during the Fourth Lateran Council were merely codifying, establishing what was already practiced in the courts during the second half of the 12th century. So you have the beginning of the Ordo Justitiaris was accusatorial, and during the course of the 13th century, it became more and more common that inquisitions would take place, inquisitions that were conducted by judges, and these inquisitions would then be able to bring a case against a defendant. And I summed up on this page, I've summed up the literature, the earlier literature, particularly Wilfried Trusen was responsible for establishing the idea that the inquisitorial procedure was completely established at the Fourth Lateran Council. But I think the work of Lautecari, which I've listed here, and others, has definitively proven that already in the second half of the 13th century, Inquisition of the 12th century, the second half of the 12th century, inquisitions were becoming common practice. But from the change of an accusatorial procedure to an inquisitorial procedure, you have the same problem, intellectual problem, as well as a religious problem. How can you justify this new type of procedure? The procedure in which the judge was free to investigate whether a crime had been committed or not. And it was through a series of canons at the Fourth Lateran Council that these new rules of procedure were established. But what was particularly important is that in the canons of the Fourth Lateran Council, Innocent III and his jurors gave the biblical justifications for why a judge should be able to conduct an inquisition, an inquisitio, into a particular case. Again, not an accusation. There is no accusation. It is only the judge which investigates into whether there has been a crime or not. Qualiter quando was perhaps the most important of these various canons that were promulgated by Innocent III. And as you can see, in Qualiter quando, Innocent also introduced the idea of fama as being an important ingredient that was absolutely necessary for bringing an accusation in a courtroom. And as you can see, once again, Innocent III and his jurors, one cannot think of this as just being Innocent III, it's also his jurors use biblical norms in order to bring these accusations against defendants. So by the beginning of the 13th century, there was another new form of procedure that was well established in the medieval courtroom, and that was the inquisitorial procedure, which had to be conducted secundum ordinem judiciarii. But the medieval jurists did not stop there. And I'm compressing the development significantly. I'm skipping over a lot of earlier developments in the jurisprudence governing procedure, but certainly one of the most important parts of their ideas about procedure and establishing a jurisprudence that governed procedure was that they based this ordo judiciarius, they based it on biblical norms, but they also based it on jus naturale, natural law. This took place from the beginning to the end of the 13th century. As I said, I'm not going to go into detail, but by the end of the 13th century, and I cite a text from Johannes Monachus, who was writing around 1300. And Johannes Monachus decides that procedure was established by natural law. And this was an extraordinarily important development, absolutely crucial for many of the norms that the jurists then developed on the basis of that idea. Up until the end of the 13th century, the jurists conceded what they read at the beginning of Justinian's Digest. At the beginning of Justinian's Digest, Justinian's jurists, drawing upon ancient Roman jurists, described the way in which procedure was developed, and they concluded that procedure was entirely based on human, that is, Roman law. However, in the meantime, because the jurists had already decided in the change from the accusatorial system of procedure to the inquisitorial procedure, and it was based on Genesis 3, chapter 12. And that is not Roman law. And by the end of the 13th century, the jurists decided that procedure, court procedure, was no longer man-made procedure, no longer just based on Roman law, but it was based on natural law because it was based on these texts in the Old Testament. And this is summed up by Johannes Monachus at the end of the 13th century. As you can see, I'm not going to read the text to you. And the defendant must be summoned. Why must the summons be established? Because it was necessary. One of the most powerful norms in medieval law is necessitas. It was a necessity. And why was it a necessity? Because the summons was part of jus naturale. And then Johannes Monachus concluded by developing and creating, for the very first time in legal history, the norm quilevet presumitur innocens, nisi probatur nocens. Everyone is presumed innocent until proven guilty. That norm, I don't think I have to tell you, that norm has entered every single legal system in Europe, in North America, and South America, just about everywhere. It's probably one of the most powerful norms created by the medieval jurists. Guillermus Durantes, who wrote his tracts just about the same time as Johannes Monachus, that is to say at the beginning of the 14th century, he took the idea even further. No defendant, no reus, would be deprived of his defense in a court. And drawing the ideas to their logical conclusion, Guillermus argues even the devil, if he would be accused of a crime in court, would not be denied a defense. Why would he not be denied a defense? Because the right of a defendant to have his guilt or innocence decided in a courtroom according to the Ordo Judiciaris, was based on natural law. And even the devil is ruled by natural law, or his rights are established by natural law. I'll give you one example of how the inquisitorial procedure developed. In December of 1299, Vecto, the criminal judge of the Podestà of Bologna, began an investigation of Mango, who had been accused of robbing the store of a silk merchant. Vecto ordered a knight, Rosario, to conduct an investigation. Rosario examined 9 witnesses, and as was necessary in the Italian courtrooms, their testimony is written down and recorded. And we know about this court case because the documents are still in the archives in the city of Bologna. They searched Mango's house. They found 4 skeins of silk. It was identified as the stolen goods. Mango denied everything. Then Mango was tortured under the supervision of 4 magistrates and a notary. He confessed to stealing the goods, and the notary recorded it. And afterwards, he confessed to other crimes. And on the same day, he confirmed his confessions before the court and Judge Vecto. And this magnificent illustration from a Vatican manuscript is the torture that Mango probably underwent. It's called the corda. And as you can see from the illustration, the defendant, let's imagine that this is Mango, is rolled up into the air, his arms behind his back. Whoop. And a weight on him. He's hauled up into the air. A judge, a notary is present. This particular illustration in the Vatican manuscript shows Mango being caught here, being tortured in the courtroom, and then he is shown having his foot cut off, which was a common punishment for a thief. Now, to turn to torture, I said that the torture was a stain on medieval jurisprudence. If on the one hand, the medieval jurisprudence developed a very sophisticated jurisprudence covering courtroom norms and courtroom procedure. On the other hand, from the beginning of the 13th century, they also began to let torture into the courtroom. And of course, torture was well known to the Romans, and through the Romans, and particularly Justinian's Digest, torture had a certain respectability in medieval jurisprudence. Perhaps the main reason for torture becoming part of medieval procedure in the courtroom was that at the beginning of the 13th century, the jurists decided that following Roman law dictated that crimes against the emperor, treachery, or if a person was a traitor, Roman law established that a person could be tortured. And from the 13th, 14th, and 15th centuries, torture was used in the courtroom, as we saw with Mango in Bologna. And at least in terms of jurisprudence, it reached its peak in the 16th century, and perhaps the best person to describe torture and the jurisprudence which established torture was Prospero Farinacci, who was a very interesting jurist at the end of the 16th and beginning of the 17th century. And Farinacci gives us the most complete jurisprudential description of torture that we have. I'll ask you to read what I put up on the left-hand side of the screen, the right-hand side of the screen, and I'll just talk about some of the issues that Farinacci raises. The first is, in the medieval courtroom, that he argued that evidence to be tortured should be sufficient, grave, and probable, and the judge, before the judge ordered torture, the judge must be almost certain of the defendant's guilt. He also argued that when proofs are sufficient, when there is almost no doubt or no doubt at all whether a defendant is guilty or not, that the defendant should be convicted and not tortured. Before a person could be tortured in the courtroom, Farinacci argued judges must have sufficient proof to commit torture, and they must issue a decree in which all the evidence is presented that a defendant should be tortured. And most importantly, and this is almost always overlooked by writers who write about torture, is that if a judge ordered a person to be tortured, the defendant could appeal the judge's decision to a higher court. If the defendant does not confess under torture, it may not be repeated unless there is compelling new evidence. If a judge repeats torture without new evidence, the confession is void. You may remember that Mango, after having been tortured, had to repeat his confession in the courtroom. That was absolutely necessary. In other words, a defendant may confess under torture, but they had to verify their confession in the courtroom. And if they, according to Farinacci, if they did not repeat their confession in the courtroom, they could be tortured again, but only once. And then Farinacci laid out the 5 different grades of torture. It was considered torture if a defendant was taken to the place where the torture was done. If a defendant was raised with the torture device La Corda, which was pictured earlier in that Vatican manuscript, the defendant was raised for the time of a prayer, Ave Maria, or Pater Noster, or Credo, but the defendant could not be tortured for more than 3/4 of an hour. Now, there are 3 common types of torture. For women and boys, there was something called the tormentum civiliorum, in which twine was wound around the fingers of the person to be tortured, and then the person to be tortured, the twine was twisted tighter and tighter and tighter. And as you can see, this was considered to be a system of torture that was used for women and boys and less serious offenses. The second most was the most common, and on the left-hand side of the screen I'm showing you another manuscript illumination, this one from Gratian's Decretum, which illustrates La Corda. This manuscript dates to about 1300. And Tormentum Cordae was by far the one that was most commonly used. And as Farinacci says, the one that is used most and approved by the Ius Commune. And then the one that was used very, very rarely was the most severe torture, and that was called the tormentum vigiale, where the defendant was mounted nude on the top of a horse and was tortured for a very long period of time. Now, you know probably that torture was ultimately abolished in European courtrooms. Cesare Beccaria is often given the credit for abolishing torture, but there were a large number of jurors from the early 16th century who had already abolished torture, or didn't abolish torture, they argued against torture. And I've listed some of the more famous of them. And Matthias Schmucko has written, I cited at the bottom of the page, Matthias Schmucko has written a book in which he talks about the abolition of torture in Europe from the 16th through the 18th centuries. But it was a long and a very slow process. I said at the beginning that torture was a stain on the development of medieval procedure. I'd make a few more comments about that. First, it was a stain on medieval procedure, and thankfully by the 18th century it had completely disappeared, or almost completely disappeared, from the courtroom in Europe. But it is also very rare. If one goes to torture museums in Europe, and they're particularly prevalent in Germany and Poland, if one goes to torture museums, you'll see instruments of torture in those museums which were never used in judicial torture. I'm making a distinction now between judicial torture, the torture of a person in a courtroom, and torture that may have been applied to criminals or other people outside of the courtroom. But in torture museums, most of what you see is just false. There's no justification for the instruments that they claim are used. The second point that I would make, and this is not to exonerate torture in any way whatsoever, but I have examined over 6,000 court cases from the 14th, 15th, and 16th centuries. And of those large number of court cases, only about 2% of those cases can one find that torture was used against the defendants. Now this is, I repeat, this is in no way exonerating the use of torture in the courtroom, but it is simply to say that the limitations of torture, which were laid out by Farinacci at the end of the 16th century, were respected. There may have been rogue judges who tortured and broke the rules governing torture, but it was rare. And with that, I'll thank you for listening, and I will turn the program over to Jorge.
Thank you very much, Professor Pennington, for this very interesting, rich presentation and for bringing us in such a long journey from the first millennium until more recent periods. Now, Jorge will give us a short commentary on your presentation, and I would like to invite all the people that are following us to prepare questions or comments.
I can talk. I hope it gets better. Okay, I want to make some remarks, of course, in the presentation of Professor Pennington, but also in a wider perspective, taking into account the writings of Dr. Pennington in the same topic of today. First, I take the opportunity to express my very thankfulness with Professor Pennington for his constant help in my professional career, even if he did not know me until very recently, and very recently is today. So I'm very thankful to you, Doctor, really. His book, The Prince and the Law, was all important to me many years ago when I was writing my book on the ecclesiastical court of the Archbishopric of Mexico. All his work has been very important to me until today. It is outstanding the way he looks at the history of the normativity and due process. I strongly recommend looking at the webpage of Professor Pennington. It shows not only very valuable information, but also a very generous man sharing his knowledge with everybody. So take advantage of that webpage, please. Okay. What Professor Pennington is showing us is a long trip. It's a long travel. A long and interesting travel from the ordeal to due process as the right of the litigants. As he says, is really a revolution. All of it according to the Roman canonical tradition, in which the jurist and post play a very important place. It is a remarkable journey to understand how it became real, the maximum that we address today as the maximum expression of justice. It is a person is innocent until proven guilty. Or, as Guillem Duranti said in his Speculum, and I'm quoting Dr. Pennington, of course, everyone is presumed innocent unless they are proven culpable. The law is more inclined to absolve than to condemn. Justice, meaning the just, is more ready to acquit than to condemn. Are you listening to me? Good. Okay. Echo runaway. Good. Secondly, it is very important the connection that Professor Pennington has been done between authority, power, rights, and due process. It is a trip from the community control ordeal, something more similar to a lynching than to a justice, to a process understood as a right based on norms and rules common to all. A trip from arbitrariness of the community to the management of the process by the authority, the process as the right of the litigants. A journey through the great jurists and popes who made due process a reality until it became a powerful instrument of governance where the rulers exercise their authority as judges. A dream from Germanic law, civil law, natural law, as an intellectual and current evolution in Western legal tradition. An intellectual revolution that put the relationship between faith and reason, and I think it's one of the most interesting things, an intellectual revolution that put the relationship between faith and reason at the center of considerations. The Bible and the reality should be connected. It means that what is based on faith should be based on reason, and what is based on reason should be based on faith. Harmony that proves the truth of the things. And it is really an intellectual revolution. My third remark is the establishment of the Ordo Judiciarius in the 12th century ecclesiastical courts and so on. This is a travel from its establishment in the ecclesiastical court of the bishops and those of the Pope to the establishment in the secular courts, and I have to say, in the courts of the corporations too, the universities, the mendicants' orders, and most important of all, the cities. In the Hispanic tradition, that is particularly interesting to me, the ayuntamientos, as those are called in the Hispanic tradition. Is this the due process was adopted for every corporation on that society. It is important the journey of the central role played by the jurists at that time as well as the papacy. A journey that showed us the biblical base of the doctrine, who leads to the natural law, who leads to the jus gentium, who leads to due process, who leads to place it within the jus commune. It is to say, as a universal and accepted practice in Western legal tradition. Yeah, it's a journey. And reading Dr. Pennington's papers or attending this conference, it comes to be very clear, and it really is, I would say, an exciting journey. Yeah, you cannot become indifferent to this. You get involved, and it's better than a Hollywood movie, really. So you have to read it. While studying these ideas, make it very clear that the revolutionary reflections of the Italian Cesare Beccaria and the Mexican Manuel de Lardizábal about due process and justice did not become out of the blue, but became from a long-lasting juridical tradition. I think it is very important in the presentation, in today's presentation, because we tend to think or to have this prejudice that everything changed in a given moment in history, and we forget this very important word, this tradition. When Beccaria was talking about, when Lardizábal was talking about, many centuries were backing the reflections. Now let's get some questions about torture and due process. It is very interesting to know that even torture was subject to rules, which is a very important way to domesticate violence, who leads to the abolition of torture. And I think the reflections all these centuries, as it was in one of your presentation, in one of your layers, is every time a jurist took this topic was rising the merits for the application of torture. So we have to think or to question, and this is more a question, if it is a way to domesticate violence, what leads to the abolition of torture. Now, much has been written about torture in the court of the Holy Office, I mean the Holy Inquisition. It is a question for us who study the Hispanic and Indian tradition. Much has been written about torture in the court of the Holy Office of the Inquisition of the monarch of the Spain. But in the Hispanic American historiography, very little has been written about the use of torture in criminal proceedings by secular authorities. Is it the same in other historiographical tradition? You already answered that question, no? But I think those who study the procedure in Hispanic tradition, we only think about the Holy Office of the Inquisition. But we have to think in the wider landscape. We have to think about that. There's a big challenge, because if not, we are not going to understand a problem that is with us, with our historiographical tradition. It is. There is an inquisitorial procedure, yes, but it's not exactly the same that was applied in the Holy Office, in the Santo Oficio de la Inquisición, because of the secrecy. And the secrecy made a huge difference. So probably we have to make a difference between I have to say it in Spanish, the inquisitorial e inquisitivo. Inquisitivo meaning the normal procedure in a secular court. Inquisitorial, the very special application of this procedure in the Holy Office. But this is something that have to be researched, and we are not going to have a clear understanding of it unless we study these kind of things in the secular courts, and this, I think, is a very pending issue in the Hispanic American tradition. Also, it is noteworthy that in the ecclesiastical courts of the bishops, torture was not used. And in fact, it was prohibited along with the death penalty. So we would also have to make a long journey from the prohibition of the torture and the death penalty in the ecclesiastical courts from the very beginning to its prohibition in the civil courts, something that in fact has not been achieved yet. Certainly not in Mexico. Yeah. Some final remarks. There are notable historical examples where due process is the great protagonist of history. Dr. Pennington, in some writings, has talked about the example of Robert of Naples versus Emperor Henry VII, or the Patsy conspiracy. The Patsy conspiracy is very interesting because the Pope wanted to jump over every due process, and even that's when they say even evil needs today in the process, that needs today in the court. What examples of these types of cases came to your mind? And this is a question for everybody. There are many examples, many that even we do not suspect that the great protagonist is due process. I think, for instance, the very famous at least in the Hispanic American tradition, this fight of the Bishop Juan de Palafox y Mendoza of Puebla de Los Angeles versus the Jesuits. All the argument in Rome was the due process has been violated by the very Jesuits. And it was said by one of the Jesuits, by the way. Or much more famous, the case of Dreyfus in France at the beginning of the 20th century. It's a clear and absolute violation of due process. So that's why I think we have become to identify due process with justice. And even more, justice is realized in the due process. Secondly, we have to think also in the development of the doctrine. For our tradition, Hispanic American tradition, Bartolomé de las Casas, and I strongly recommend to read the Bartolomé de las Casas paper of Professor Kenneth, and also the talks he has in his webpage, about Bartolomé de las Casas. I enjoyed that very much. Dr. Pennington, thanks to send it to me. Bartolomé de las Casas, the Bishop Vasco de Quiroga, the father-founder of the bishopric of Michoacán. Alonso de la Veracruz, talking about marriages. Solórzano y Pereira, who was always arguing that justice could not be accomplished without due process, and he was looking all the time if the due process was right or wrong. Santiago de Villarroel, the Bishop of Chile and Archbishop of Peru. Or even, and this is dedicated for you, the case made by Suarez and the doctrine of the tyrannicide. A king does not apply due process, becomes a tyrant. That important it is. How do you know that the king is becoming a tyrant? Because he's not applying due process. This is the base of the argument. Yes? Because he's killing without mercy, because due process is not being accomplished. For a person who deals with judicial history and justice, I have to say, understanding what due process is becomes a matter of life or death. I mean, academically, of course. Torture will not be applied, but probably you can lose your job, and that's even worse than torture. But for a person who deals with judicial history and justice, understanding what due process is becomes a matter of life and death. But also for all those who use judicial sources to do another type of historiography. I want to recall, as I recalled in previous sessions, the reflection of Dr. Charles Donahue about this particular thing. Many errors that we find in the production derive from not understanding what the judicial process is, because without it, the sources themselves are not understood and the reconstruction of the past is full of errors. I have a good example of it that I will not mention, but everybody knows that this using judicial or records and for not taking into account due process, everything leads to wrong conclusions. And two more things. All this journey that Professor Pennington showed us, all this journey has to remember us the close relationship between due process, truth, because due process is there because it's looking for the truth. Relation due process and truth, mercy, and justice. Within the development of the ecclesiastical court in the Middle Ages and modernity, something that has had a great impact in further developments of criminal law. And I want to finish with something that I think it's absolutely important to keep in mind in doing this kind of research. Law, meaning jus, meaning diritto, meaning recht, meaning derecho. I hate the English language have this limitation, Professor Pennington. No, it's the confusion between law with capital letter and law with a little one. So law, as in jus, diritto, recht, derecho, is a very important part of a culture. But it also has a powerful capacity to generate culture. It creates culture. El derecho is culture, but also creates culture. We cannot leave the production of law in the hands of irresponsible people, and that is why historical studies are so important. And thanks, Dr. Pennington, for everything you have given to us.